Welcome to this video. In this video I'm about to explain the American court system. To simplify this, let's imagine there's a person named Michael. Michael is accused of a crime in the USA. As long as Michael's guilt is not proven, Michael is innocent. As an example, Michael is accused of breaking federal law, a treaty or a statute. First, Michael will go straight to the federal court system. These start in district courts, also known as general trial courts. The United States District Courts are the general trial courts of the United States federal judiciary. In USA, there are 94 districts. The number of districts varies everywhere. Some states just have one district, other states more than over 10, but there are also US territories which have their own district courts. A trial court is headed by one judge and convinces with or without a jury. The judge is appointed by the president and confirmed by the US Senate. They can serve for their whole lifetime unless they misbehave. At the district level, there are also subject-specific courts. Subject matter jurisdiction is the authority of a court to hear cases of a particular type or cases relating to a specific subject matter. For instance, bankruptcy court only has the authority to hear bankruptcy cases. Back to Michael. So if Michael is found guilty in the trial court, he can appeal to the higher instance, the circuit court, also known as US Courts of Appeals. The party filing the appeal is called the appellant and the other party is called the appealee. In a court of appeals, only issues of law may be raised. Some of the circuit courts also deal with specific subjects like military matters, for example. But what if Michael is found guilty in the appellate court? If Michael is dissatisfied with the decision of the appellate court, he may petition to the Supreme Court, based in Washington, D.C. This court can review the decision. He will have to petition them to hear his case. For this, a writ of certiorari is required. The writ is addressed to the Court of Appeals, ordering it to certify the record in the case and send it up to the Supreme Court of Review. At least 4 justices must vote to grant certiorari in a case. But what happens if his writ of certiorari is denied? If Michael's writ of certiorari is denied, it simply means the appeals court decisions agrees with the current law. But they are very strict. Less than 1% of all appeals are heard by the Supreme Court. The US Supreme Court consists of 9 justices who are nominated by the President and confirmed by the US Senate as well. As like for the federal court system, the justices can serve for life unless they misbehave. The US Supreme Court hears in average about 76 cases each year. They meet by beginning of the first Monday of October until the coming summer. The Supreme Court combines lower court appeals into one case, or the cases even begin at the Supreme Court, which is called original jurisdiction. A typical example for this is when there is a dispute between 2 states. This is quite similar to the Organstreitverfahren in Germany. Now, if the Supreme Court rules against Michael, that's it. But sometimes the US Supreme Court overrules its own decisions by deciding differently in similar cases and aspects. So that's it for Michael. He is guilty. Now let's head over to Angela. What if Angela's breaking a state law? What happens then? State courts handle the vast majority of civil and criminal cases in the United States. The much smaller in case load and personal United States federal courts handle different types of cases. State courts are common law courts or courts where judges use precedent or previous judicial decisions to interpret state laws. They are courts of general jurisdiction. A court of general jurisdiction is a court with authority to hear cases of all kinds, criminal, civil, family, and so forth. Depending on which state or jurisdiction state, court judges can be appointed by the governor for life, appointed for a limited time, or elected by its citizens. What do you think? How many cases and then guilty pleas and never will settle to a trial? More than 90% of all the cases. But what if the case gets to trial, similar to federal courts? State courts also have district courts, appeals courts, and supreme courts. So if we imagine Angela's found guilty at every stage in state court, what can she do? She could appeal to the Supreme Court, but the chances of them hearing her case are very low. So much for that, let's change the subject. What if Angela wants to sue someone? This would be a case for a civil court. A civil case which can happen in state and federal courts. First, she will need to talk to the person or businesses, defendant, to let them know that she is suing him or her and why. She can demand the defendant for payment or try to get the court through the order the defendant to refer for the behavior for what she sued him or her for. The court itself cannot collect the money for Angela. Judges will try to find a solution before going to court, but eventually she will get a trial. If she gets to the jury or a judge, she'll need to convince them by preponderance of the evidence. So it has to be clear the person she sued hurt her. And if she loses the lawsuit, she can appeal to the higher courts, just like Michael with the criminal cases. That's it. Thank you for watching. I hope you enjoyed the video. If you click on the video on the right, you can see how the video was created. In this video you can see how I edited the pictures, added the animations, the texts and so on. It was a lot of work. Thank you for watching.